So, if you say you own a particular property, people being nosy as they are may want to start to say that property is X, Y, and Z, and also the things will come up. You then get down into how did he acquire that property, how did he acquire those shares, how did he acquire those bonds, and then you leave the issue of governance and then you concentrate on personal issues.
Well, some people would say, Honorable Atunwa, if I may just come in here, some people would say that those are legitimate questions. Those are questions that the agencies by themselves, I mean, ought to have been asking before now. You were talking about knee-jerk reactions. What then do we make of, is it the musings in some quarters that the senators were then thinking of doing an immunity clause to protect them from prosecution?
Well, I haven't heard that personally, but if that, let me share my own opinion on that. I don't believe that the legislators should have any immunity from prosecution. I actually am not a firm believer in immunity. I think we should all be subject to the law. We should all be subject to prosecution if we carry out an illegal activity or an illegality. So I am not a great advocate of immunity. Beyond what we know in parliamentary terms as the parliamentary privileges, that is to say, anything you say in the chamber of the House, the floor of Parliament, then you are immune from prosecution on that basis. So that, for example, if I said something in the course of an argument or a debate in the floor of the House, I shouldn't be subjected to laws of defamation or prosecution or one thing or the other, because I should be free to express my mind as a true representative of the people, a true representative of my constituents, to express my mind without fear of being prosecuted. Now that's fine. That's limited to what you say on the floor of the House. But beyond that, I'm not a great advocate of immunity for any class of persons at all.
Okay, that's on the one hand. Now, from all that you've listed, I mean, it would seem that there are so many pitfalls for this particular case. I mean, both on technical grounds and even looking at some of the merits of the case. And it would seem that that is what the defense will be putting forward. But as it were, why then did we need the business of the day to stop at the Senate? Because 81 senators accompanying the Senate president, obviously, our lawyer here said that it was a no-brainer. It was a political message. Was that really necessary?
Well, I can't. I'm not a member of the Senate. Well, I can't comment as to what inspired 81 senators to accompany the Senate president to the tribunal. But I can say this, that inasmuch as the quorum for the Senate being at the moment presently constituted, I think, 108 members, is 1/3. I think that would give you, if my arithmetic is right, something in the region of 36. If 81 have accompanied the Senate President to the Code of Conduct Tribunal and signify their intent so to do, I can only guess that they wouldn't have arrived at a quorum if they attempted to sit. So, but that's a matter for the senators. They constitute their house and organize their house as they see fit. But I don't think anything is lost there really in the business of the day not being carried out for one day, if that's the wish of the representatives of the people in the Senate.
No, but the chances are high, sorry to interrupt, Salai, but the chances are high because the trial is not over yet, that for as many times as the Senate President has to appear before the CCT or even maybe the appeal court, that this may be what will happen, that the business of the day could be stalled.
Again, you're trying to draw me into affairs of the Senate, but let me say our senators are eminently sensitive. So when they get to that bridge, they will cross it. I'm sure they will act in a manner commensurate with the court's duty.
Yeah, but Honorable, I think, why did the House of Reps themselves adjourn sitting after briefly to yesterday?
Yes, the House of Representatives sat, the Speaker attended on time. Some bills were read for the first time, and thereafter the business of the House was closed in order to enable the Speaker to attend the Council of State meeting which I believe you've alluded to in your news item, where in the news item, beg your pardon, where certain important decisions that affect the country were taken, including the confirmation of the Mahmoud Yakubu, Professor Yakubu, who is of course, now the INEC chairman. So the speaker had to leave. The deputy speaker is away at the Interparliamentary Union in Geneva, attending again on matters of serious general public importance. So the House had no option but to sit for a short while, having dealt with very important bills, and then adjourn. It had nothing to do with, of course, with the Code of Conduct Tribunal, if that's where you're going.
In all of this analysis from you, it would seem as if we have so much to do in terms of constitution amendment. You've been a speaker in the Kwara State Assembly, and you're also a lawyer who's seen how parliamentarian business is done in other parts of the world, specifically in the UK. Don't you think it's about time the National Assembly, specifically even the House of Representatives, moved into looking tweaking the Constitution? If you say the CCB hasn't done what they should have done by waiting that long before coming up with this particular matter, what else do you think that as a lawmaker, you can do on the floor to making sure that the CCB is better strengthened and put in a better position to help the nation?
Again, I'll address your question is somewhat in two parts. Let me say quite clearly again that it's the law, in as far as I'm concerned, on this particular issue, seems to be adequate. It is the operation of the law, those who operate the law, those who administer the law. That's where the fault is. Now, for example, as I've said, it took them a number of years to prefer these charges. And then when they came to prefer the charges, not only did they breach certain rules or procedures by not having an Attorney General designate the person to sign it, or indeed instituting it himself, they served a summons on a defendant on a Wednesday evening, asking him to report for trial on a Friday morning. Now, you've taken 12 years to bring charges. Now, with less than 48 hours, you're asking him to come to trial. You served him a summons. You haven't served him the full evidence of the case in which he needs to meet, the case against him. You haven't allowed him the opportunity to consult a lawyer. You haven't afforded him the opportunity to get his witnesses in order, to get his facts and documents in order. You say you report to trial in the next less than 48 hours.
You've said, sorry to butt in, you've said that much before, but it still goes back to, implementation of some of this. If you're putting the whole blame on those who would implement the law, it goes back to the Assembly. If we see that we have this difficulty in implementation, that should also be some kind of concern or worry for the legislators.
Yeah, and it should be a concern to every citizen of Nigeria. Because today we're talking about the Senate President, tomorrow we're going to be talking about any ordinary citizen of Nigeria. What is important is that those who administer the law should do what is right, rather than write roughshod over people's rights. Look, it doesn't take a scientist or a genius to say that you can't serve a summons on someone on a Wednesday and ask him to come for trial on a Friday morning on a 13-count charge of something as antiquated as 12 years ago. So what matters is to train and retrain those who are administering our laws to see that they comply, not just in substance, but also in form. The Constitution is quite clear. Everyone has a right to fair trial. And part of fair trial, every lawyer knows, every law student knows, part of fair trial means that you must afford the defendant the opportunity to seek legal advice and prepare his case. Now, you can't prepare a case in another 48 hours. It's not possible. So it should be a concern to all of us. It's not a concern solely for the National Assembly. The laws, as I say, are quite clear. Now, beyond that, moving on from that specific, You recall that our Speaker, House of Representatives, constituted a multifaceted committee, of which I am a member, to look at all the laws of the Federal Republic of Nigeria from inception. We are working hard. We've been at it for about just over 2 months now, I believe. In the shortest possible time, will submit an interim report, because the task is a Herculean one, where all the professors, the senior advocates of Nigeria, some members of the House, and members of including the civil service, are members of this committee. And we are looking at all the laws of Federation of Nigeria. Where amendments are required, we will propose those amendments, and of course, we will effect them at the National Assembly. And I'm sure you're also aware that the National Assembly was in the process of finalizing the constitutional amendment in the last Assembly, but wasn't able to conclude that matter. I'm pretty confident that we'll raise its head again, and this time we will start in good time to ensure that the Constitution is reviewed and amended as required.
All right, Honorable Razak Atunwa, thank you for talking to us today.
Thank you very much.
All right, and so we'll be back. We've got another perspective on this same matter, so just hang on. We'll be back.